Okay, just for your information, the exam on Chapter 6 is due tonight. Some have done it, some have not, so make sure you get that in by 11:59 p.m. And we're moving on to Chapter 7, Legal Research and Analysis. This is probably one of the most important chapters because that's what paralegals do. That's why attorneys hire them to do legal research, analysis, drafting documents, things like that. So you have to know how to research to be able to help your attorney and your client. While you're here at Cape Fear, you have access, wherever you are, to Westlaw, which is a huge deal because it's very expensive and it's free for you guys because Cape Fear pays for it. It's like $8,000 a month or something ridiculous. And it's a valuable tool, and you can, once you are good on Westlaw, you can put that on your resume. So that's the story. You go to Westlaw and just explore it anytime you have free time or when you're watching a football game or something. Just have that on and go for it. All right, Chapter 7 starts on page 174, and you always read the chapter objectives. And you're going to learn how primary and secondary sources of law differ. We know primary sources are the law. Secondary sources are not the law. They are like an encyclopedia helping you find the primary law and cases. It can help you find cases in your jurisdiction. It goes into how court decisions are published, and how to read case citations. We did a little bit of that with the Cathay case. How to analyze case law. We'll get to the IRAC method. And summarize and do a case brief, although I don't think I assigned a case brief in this chapter, but not sure. How federal statutes and regulations are published, and the majority major sources of statutory and administrative law. I'm not going to get into how they are. You probably learned how they are passed. You probably know that from civics class, but the information is in here. What a lot of paralegals have to do is interpret statutes. So you have to be able to read a statute, understand the statute, and see that if it applies to your situation. All right. So make sure once you go over the chapter and listen to the lecture, you can meet all the chapter objectives. When you're in a law office setting or a legal setting anywhere, you may be asked to find a case or a statute. You may be asked to analyze a case or summarize a statute, and that's why I do a lot of statute comprehension and case comprehensions. Page 175, it starts out that the preliminary steps. The preliminary steps. After you interview the new client, which a lot of paralegals do that. A lot of attorneys like to do it themselves, but have the paralegal present taking notes. But a lot of paralegals do the initial interview with the client. And you're going to have to get all the facts, and they have interview sheets for different kinds of things. They have them for divorce, personal injury, probate. So it would be the different kinds of interview sheet that your law firm will have in their files, and that's what you use. You're going to need to define the issue in your client's case. They give you a hypothetical in their book, the one about Hoffman versus Better Homes store, where the customer came in, bought a mirror, he ran into a pole carrying the mirror he bought, shards of glass went into his eye and he lost his eyesight. You may not know what the issue is yet if you haven't had civil injuries, LEX 130, but it's premises liability and it's a personal injury case. The issue, and it's not important that you know this if you haven't taken civil injuries yet, is a tort and negligence. Was the store owner negligent in leaving the pole, putting a pole where customer would hit it and injure his eye? So you define the issue, and then you need to start researching it. And on page 176, This is a civil injuries, and it's a tort of negligence, and they give you the elements, and you would get the elements. If it was a trespass case, you would look up trespass and get the elements of trespass. So the elements are duty of care to plaintiff, the injured guy, the defendant, store owner, breached that duty, the plaintiff suffered a legally recognizable injury, he lost his eyesight, and the injury was caused by the defendant's breach, plain and simple. It's a little more complicated in LEX 130, but those are the elements that apply to your case. If there was a client comes in and she's been divorced and the husband's not paying child support, then we go to the statutes on arrears and child support. What can we do to file a lawsuit to make him pay the arrears and get current in his child support? So what you first try to do is to, of course, read the statutes, read the elements of whatever claim it is, and find a case on point. A case on point. A case on point is a similar case involving the same factual circumstances and issues. Same facts, same issues. That's a case on point. It differs from a case on all fours, and that is on page 178. A case on all fours are the parties are similar, such as the one in the book, a customer and a store, a husband and a wife. The parties are similar. The circumstances are similar. I had a personal injury case here when I first got to Wilmington, where at Dick's Sporting down on College, which is no longer Dick's Sporting, it's Floors and Moors or something. My client was in the store. He had on flip-flops because we live at the beach, and there was a fire extinguisher on the wall that wasn't bolted in correctly. It fell on his foot and crushed his toes, and there was blood and broken bones. So that would be a similar case to the one with the pole and the store and the customer. The parties were similar. The circumstances were sort of similar. There was a fire extinguisher placed by the management, the owner. The legal issues are the same. That he was injured and he wants damages, and the remedy's the same, damages. Just by the by, and I think I said this in my lecture last year that's already posted, apparently they don't care much about a damaged foot in the courts here. He only got $6,000 for injuries, but you know, that's what it is. And of course the attorney gets a third of that. So, all right. In chapter 5, we went over the sources of law. And so you know that you have to, on page 181, you have to find a relevant case. Does anybody remember what a binding authority is? You want to locate binding authority, and binding authority can be a precedent in your jurisdiction. Such as we have to follow the North Carolina Supreme Court, the Court of Appeals. So we find relevant cases, and you use the encyclopedias, Amjur, Corpus Juris Secundum, to find similar cases on your point. And this would be store owner owing a duty to a customer. Just like store owners, we don't get much down here, but when it ices in other parts of the state, store owners, if they're open, they have a duty to clean the ice off, put down rock salt. I think that's what it's called, salt, rock, to get the ice gone if they're open and open for business, so no one slips and falls. They have a duty to repair the stairs or the steps leading up to their store. So you want to use the legal encyclopedias to find binding precedent. If you can't find binding precedent in your jurisdiction, what do you do? If it's a case of first impression, you go to another jurisdiction, and that's persuasive, but it's not binding. I want you to look over, if you have your book with you, on page 182, premises liability. There's an excerpt from American jurisprudence, which we do have in our library here on North Campus. And it will give you the basics and where to go to file, what you need to file premises liability. And that's what this case is. Most of the research now is done on Westlaw or on the internet, LexisNexis, but in the hardbound copies, we have what are called pocket parts. They're going out of style because most of everything is going to the internet. But you always would check the pocket part in the hardbound copies because it's an update to the bound copy. Right. We also have case digests, and in North Carolina, we use Strong's Index and other ones that are posted on Westlaw. So we're getting into Strong's Index, where it's arranged like an encyclopedia alphabetically. And one really huge benefit with Westlaw is the keynote system. We've been exposed to that a little bit. I've got one posted on the board. I'm going to share my screen. And we'll go here. This is a lot of what I'm saying right now, so you can read that. But let's see. Seriously, did I not put it up? Yes, I did. Come on. Oh, here we go. Disregard. Here it is, page 184, first thing. Page 184 in your book shows you this page, and it shows you an excerpt from West Federal Practice Digest. All right, so it's federal law on negligence. And this is a keynote. West Keynote 1037, paragraph 4, subsection 4, whatever, will show you, when you scroll down to that, the duty of care required of the store owner, all right? And it'll take you to all the cases. There's one, Higgins versus White Sox Baseball Club, Inc. There's another one. All right, so that's where you find cases. This is a federal digest, and the state digest are the same. Throughout the whole system, this keynote will always be for negligence. So any cases under that topic, standard of care, care required in general, will be under that head note. So once you have the head note, you've got a license to go. You can find it in all of the material. Anybody understand that or not understand that? Okay. In Cathay versus Cathay, remember there were two head notes. I think it was divorce and trial and error, something like that. And those were the two head notes, and you would find those head notes. Use those head notes if you had that same type of case. Okay. We're up to page 188. I'm back. Case reporting system, you know a bit about that already. North Carolina uses the Blue Book. The Blue Book. We don't use the AWLA, whatever that is. The Blue Book is what we use. And so you have to do all your citations according to the Blue Book. And it's a uniform citation. It came from Harvard University. They started it years ago. And when I was in law school, the Harvard Blue Book was about that big. It was a little pocket-sized thing, and now it's bigger. So I got this on the internet, I think, for $18. But your law offices would certainly have the Blue Book for citation. I still refer to it a lot. I don't know if it's because I'm old and my memory's going, but I just want to make sure I'm able to understand the case citations and how to cite statutes and how to cite rules, administrative rules. So I think we've done a little bit of this already. The reporters and how to do a case name, a case citation. Right? On page 189, you have the case name. It's also called the style of the case. And we use surnames only, no first names. You underline or italicize the case name, the style of the case. And then the comma after the name is not underlined. They just want to make it as difficult as they can. Then you have the volume number, the name of the reporter. What's the name of the official reporter for the Supreme Court of North Carolina? Okay, North Carolina Reports. So then we have, I don't know if I did an example or not. Let me see. Where did I go? Ah, no. I quit. I don't know how it got to that. All right. So I would be telling you, showing you on the board, volume number, the initials, the abbreviation for the reporter, N, capital N, period, C, period, for the North Carolina Supreme Court, and the page, and then in parentheses, the year. If it's found in more than one book, the unofficial reporter, you know that you have to do the official reporter first, not the year at the end yet. You do a comma after the page number, and then you do the unofficial report, and the year goes at the end. I have no idea why that happened. Let me get out of here. There we go. Okay. That was the page 184, 185. Did I already do that? Yeah. Okay. So here we go. Textbook summary. Nope. Well, you do have an extra credit option on page 192 in your book down at the bottom. There's a federal courts banner, and it shows that blanks for the citation for the official reporter. If you've got your book, you'll see what I'm saying. And it doesn't give the name of the case. So if you look up, find the book, the volume and the page number and the name of the case, you can get 25, how many points? 20 points by Halloween. All right. On page 190, there's a map of the United States, and it shows you where the federal national reporter systems are. National reporter systems. We have the regional reporters, we have the federal reporters, and it tells you what areas they cover, what jurisdictions. So for extra points and participation, let me get my Post-it note. What reporter is North Carolina in? What reporter does North Carolina use? Anybody? Anybody still here? Southeastern, that's correct, Jessica. 5 points. Thank you. What reporter is from Missouri? Cases from Missouri. Anybody? 5 free points. Don't have your book open. Yes, Marlene. Are you able, do you have a microphone? Missouri? Nope, not the Southern. Anybody else? Okay.
Is it Southwestern?
Missouri is in the Southwestern. Would a case from Tennessee be precedent in North Carolina? Yes or no? Okay. It's a whole lot easier in the classroom because I can glare at someone until they answer. All right, we'll move on. Oh man, I hate it when that happens. No. No. Now I'm lost. Stop sharing. Oh, I tell you. Life goes on. Page 191, you do need to know the different reporters. And for federal cases, the district court is in the federal sub. Yes, Len?
Before you move on,
Yeah.
if I use a case from Tennessee and North Carolina, it's not a binding precedent, but I can use it, right?
No, it's not binding at all.
No.
It could only be persuasive, and you'd only use it if there are no cases in our state.
That's right. Okay, good. You get 5 points.
Do you? All right. Okay. So federal cases, district court is the federal supplement, and it's abbreviated F, capital F, period, space, SUPP. And there's a space because the Blue Book rule is if it is more than one letter, you have a space. Like North Carolina Supreme Court is NC, and they're both one letter, so there's no space. It's N period, C period. But because the federal sup is more than one letter, there's a space. There's a little nuance with that. If it's the federal supplement second series, the 2D stands for second series, is considered one letter. So they just try to make you complicated. I think they sat around a table saying, how can we mess with people's heads? So Fed period sup with a space. The Court of Appeals cases for the federal district are in the Federal Reporter, abbreviated F period. And then there's a second and a third series. The Supreme Court of the United States on page 191 has an official reporter, and it's abbreviated U.S. It's the United States reports. There is a unofficial version, Supreme Court Reports, S space CT. And then there's a really unofficial lawyer's edition published by West, lawyer's edition, capital L space ED. And that's when we got to page 192 about the extra credit that I already showed. Down at the bottom, if you can send in the volume and page number and the name of the case, you can get 20 points. Just see if you can look that up on Westlaw and find it. All right, the statutes. Federal statutes are published in the United States Code, federal statutes. They're passed by Congress, and we, I believe, still have those in our library, but they are accessible on Westlaw. And it's designated U.S. C. United States Code is the codification of the United States statutes at large. They first become statutes at large, and then they go into the code books. And that's, I forget how many titles, but I think there's like 25 titles, maybe more. And this one in the book is Title 18, United States Code section. We also have statutes, the UCC, Uniform Commercial Code, and it's a federal Uniform Commercial Code, and there's also state Uniform Commercial Codes. The Code of Federal Regulations, we know that only Congress and legislatures, state legislatures, can pass statutes, can pass laws. And so when an agency makes a rule, it's a rule or a regulation. It can't be called a law because the Constitution says only the Congress can pass laws. Okay. Page 194, analyzing case law. This is a very vital part to know for your life as a paralegal, how to analyze case law and to know the components of the case. They have an example of a case in here, and they label the parts, and we did that for the Cathay versus Cathay back in the previous chapter. So you can go over that. Components of the case. Okay. What I'm concerned about is starting on page 201, the analyzing the cases, and you know the different types of opinions, and they're in Exhibit 7.8 at the bottom of the page: concurring, dissenting, majority, a memorandum, when they just cite something as memorandum and it does not create precedent, plurality, and unanimous. Those are the different types of case opinions. When you get to briefing a case, you need to give the full citation. Always underline or italicize the case name. You go over the facts briefly, and the facts are not the procedural history of the case, not what happened in the lower court, but the facts of the case that got the plaintiff and the defendant into court, not procedural history. Some attorneys will want you to do a procedural history, but that doesn't go in the facts. That goes in a separate category, labeled procedural history, and that's usually a synopsis right under the case name in the cases on Westlaw. All right. So the facts are the reasons for the lawsuit, what got them there. And the hypothetical case here would be the customer came in, bought a mirror, hit a pole, glass in his eye, and lost his eyesight. The issue is always in the form of a question that can generally be answered yes or no. Sometimes it's maybe, but mostly it's yes or no. So you state it in the form of a question, and you include in the statement of the issue the key facts, only the key facts, and the relevant rule of law. So for our hypothetical, it would be, is a store owner liable under negligence law when a customer comes into the store, purchases a mirror, runs into a pole placed by the store owner, and injures himself? Under the negligent laws of North Carolina, does a store owner have a duty to keep his store free of defects? Does he breach that duty when there's a customer that is carrying a mirror, runs into the pole, and damages his eye? And you can answer that yes or no. So if it's a statute, I'll go to murder. Under North Carolina law, statute 14-17, when a person lies in wait, hiding in some bushes, when his victim comes home, he jumps out and stabs him, is that first-degree murder under North Carolina law? My facts would have been the guy was waiting in the bushes. I should have given you the facts. And lying in wait with a knife, waiting for someone to come home, is first-degree murder. So once you state the issue with the relevant facts and the key law, the decision, also known as the holding, is a yes or no. The reasoning is the largest part of your case brief, because you need to explain how the court applied the law to the facts and came up with their holding. Okay. In law school, we use the IRAC method. The IRAC method, I stands for issue, R stands for rule, application, also reasoning, application, how they applied the rule of law to the facts and came up with a conclusion, the analysis. Okay. Analyzing statutory law. Your book says there's a two-step process. First, you have to find the statute you need, and you actually have to read it. And you will find that many statutes written by any state legislature and Congress are pretty difficult to read. I don't know why they can't write them more simply, but they don't. So some are real simple and easy to read, but some statutes you will see refer to several other statutes while they're defining this statute. So you can't just glaze over that other statute. You have to go to that statute, read that statute, and then come back to the statute that you are reading. So you have to read the language of the statutes. Okay. They will give you the purpose of the statute, usually in the first few sections. The reasons for the statute's enactment, make sure it's effective, make sure it's current, hasn't been repealed. The class of parties to which the statute applies, the type of conduct it's regulating, and what is prohibited, required, or permitted. So you first read it. Then you got to interpret the meaning of the statute. Does it apply to my client's set of facts? You'll see words like must, the person must, or the person shall, or the person may. So when it's must, that's what you got to do. When it's shall, that's pretty much what you got to do. When it's may, you don't have to. All right. Researching administrative law, they're in rules and regulations, not statutes. They're in the Code of Federal Regulations on page 209 in your book, Code of Federal Regulations. And they use the same titles in the United States Code, which is nice because you only have to go one place. So that's the other thing about administrative law is it's quasi-judicial. It's almost judicial, but since the Constitution only gave that power to Congress, they can't be called laws. They have to be called rules. So they're quasi-judicial. However, they're given full force and effect as a statute. Full force and effect. We make it up as we go along. That's what we do. Okay. All right. Let me go over here. You do have, this is always dangerous when I try to do this. All right. When you're looking for cases, I'm not sharing that, am I? Am I sharing the application screen? No. There we go. There we go. There we go. Okay. When you're looking for cases, sometimes you'll come across a case that says that it's unpublished. Unpublished opinions. Unpublished opinions don't mean they're bad decisions. It just means that it doesn't provide for any new laws. It goes along with other past laws. So in North Carolina, Rule of Appellate Procedure, oral argument and unpublished opinions, it just means that there's no change in how the court ruled from previous opinions. And for limited space and cost to print every opinion, they opt out and don't print that one. It's called an unpublished opinion. The court doesn't really want you to use unpublished opinions, but you can use unpublished opinions if you share it with the other side. It does not constitute controlling legal authority because it hasn't changed anything. So you really don't want to use an unpublished opinion. You want to go back and find one on the same issue that is published, but you can use them with permission of the court and allowing the other side to have a copy in advance to show that you're going to be using that. You're going to have an assignment to do some textbook questions, and you need to make sure you go to the sections I label. Some people aren't doing that. Questions for review, and then practice questions and assignments. This is the assignment where you're going to be accessing Westlaw. Right here, Westlaw Research Assignment. And this will show you how to do Westlaw. Does everybody know how to log into Westlaw, or do you need me to show you? Anybody? Everybody knows how? Last chance.
Yes.
Don't be shy. Everybody knows how. Okay. All right. So I tell you how to get there, then you scroll down. And this is the assignment. You're going to first type in the search bar 261 North Carolina Appellate Court 557. And then you're going to write the full citation of that case. The full citation is style of the case, and then that, and then the year in parentheses. And then I tell you exactly what to do. If you read the instructions, you can do this. All right? So that's your assignment. It's going to take you a while, especially if I said 4 to 5 hours, especially if you first time on Westlaw, but you can do it. You can do it. Okay. I will stop recording now. If you have any questions.